Or I might say, are there other principles that are involved? Like, if you're saying you want to pursue this case, over this $90 worth of ducks, we were talking about this break about the case we had in Rolling Meadows where the guy had some ducks silk screened onto some little bags, and he didn't like it, and he sued over it, and he got an offer of $60 in mediation, and he didn't get that, and I think the trial judge just threw it out. He didn't get anything in the trial, so he almost had $60 in mediation. He blew it. He ended up appealing that to the Illinois Court of Appeals, $90 ducks, right? Now, one way to look at that is to say this person is very principled and they feel they have been wronged. But I'd say there are other principles involved in that. Like, what about the taxpayers of Illinois paying for your $90 appeal, huh? What about us? Do we get any kind of shake in this thing? I wouldn't say that, but I think you ought to consider it. What about the principle of, is that an appropriate thing to do with the court system? Force them to listen to an appeal of a $90 case, and why? Or you can say, well, let's talk about your principles. I have a lot of respect, and I do, for people who live by principles and who honor principles and who obey them. I think that's great. I struggle with it. And I have a lot of respect for people that can do it. But I'll ask, given that, you've got high principles and you're a person of conviction and you're a person who really sticks to your principles and you're willing to see them through, I want to just accept that at face value. But what I want to ask you is, where is the point, or is there a point at which you feel you have done all you should do, can do, and should do, and you put all of your money and your time and your effort and maybe your family's time and effort into this thing? Where's the point at which you've done all you can do and you should now pass the torch on to somebody else? This is it. This is all you can do. You can't go any further. Because I think that's fair. I think they should think about that, even in a matter of principle. Where is that? It's not. Now, what you don't say is, you don't say, what are your principles worth? What would you sell them for? That's the wrong question. The right question is there a place where you've done all you can do, and you need to move on with your life? The last two I dearly love. Can things get worse? Now that has a very interesting effect in a mediation. You sit there for several hours and you work with people, or maybe this is a good sort of middle of the game question. And you look at them very seriously and quietly, and you say, I'm just curious about something. Is there any way this can get worse for you? Is there any way this can get worse for you? Now, why do you suppose I asked that question? Because I really think it has the effect of people on people oftentimes. This is really mean, I grant it, but it's very effective. They think to themselves, he sees something. What does the mediator see that we don't see? There's something there and he sees it. What is it? Now, I don't see a damn thing most of the time. I'm just sitting there, scratching my head like, where do I go now? And that's when I ask this question. Now, it's not totally puffery, because I remember doing a case once in which we were 3 or 4 hours into it, and all of a sudden the respondent settled. And I thought it was odd. They kind of did 180 degrees around, and all of a sudden wanted to settle, wanted to put some money on the table, wanted to get it done. And in talking to the respondent's attorney, what I learned from him was that the reason he settled it was he did not think they had a discrimination claim, which was the case that's on the table. But he thought that they had just an ordinary contract claim. And somewhere in the mediation he realized that. And he figured that somewhere down the road, someplace, some lawyer was going to figure that out. So they might as well settle it now. And he did. So there is something sometimes to the idea that things can get worse for you. One of the places that you're going with the idea is they get poking around your company, asking a few questions, talking to your employees, and things get worse. My sex case, the shower thing that I did, I asked that question there too, because I thought the answer to that was pretty obvious. what would the follow-up question be? So how many years do you get for rape in Georgia? And did they have air conditioning in those prisons? They didn't used to. You know, I mean, that's a fair question. I think. So can things get worse? Now, my last one here, I'm confused. Now, this is the all-purpose mediator's question. I am confused. I'm confused. And here's how it works. You have a complainant, no, let's say you have a respondent, and you spend a couple of hours with them doing the whole cost-benefit thing. You know, what are your costs going to be? How are you going to proceed with this thing? What do you think they're going to do? Well, I think they're going to take it to the commission. They're going to get us a right to sue letter. They're going to sue us in federal court. I believe we're going to prevail on a summary judgment. Well, good. Tell me how much it's going to cost you to get the summary judgment. Well, you know, attorney's fees, a few depositions, a little discovery, da-da-da-da-da. We'll probably spend somewhere between, you know, $25,000 and $40,000 getting this thing wrapped up in summary judgment. And that's when I just look at it and say, well, now I am really confused. And they'll say, what is that? And I'll say, well, I guess I don't understand. If you have a minimum of $40,000 worth of exposure on this case, help me understand why you're only offering $15,000 to settle it, because I don't get it. Help me understand. Now, am I really making a judgment there? No, I really don't care what they offer to settle it. Do I think they shouldn't? I don't know what they should do. But it is a little confusing, right? Just kind of logically in your head, you're thinking, well, if your butt's hanging out the window to the tune of $40,000, how come you're only willing to pay $15 or $15,000 to keep it from getting shot off? I don't get it. I'm trying to help you. Remember, this is for you, so you tell me. Why are you doing this? That's fair. It's a fair question. Because I know the answer, which is what? It doesn't make any sense, and we got some more money. We're just not telling how much, and that's when we can start talking about how much, right? That's when I can say things like, well, okay, you got some more money. What's your concern about putting it on the table now? Where do you think you're ultimately going to end up going here? Now, there are some problems with that, because sometimes people look at you and say, well, yeah, we got $40,000 worth of exposure, but try me. $40,000 will buy you a lot of legal fees. Dance people around a long time for $40,000.
And I'll pay my lawyers $40,000 before I'll ever.
I'd rather give my lawyer the $40,000.
Absolutely. You know,
You could do that. That's a possibility. That's where I say, okay, well, let me then help me understand. Help me to understand how it benefits you to pay your lawyer $40,000 to run you through the ringer for the next 2 or 3 years. Go through federal court, risk. You've talked about, and I'll try to incorporate what they've talked about as the downside: risk to your reputation, lower productivity, small percentage of chance that you talked about that you could just flat lose, because there's some percentage of chance a person can lose. If anytime I have somebody who says I cannot lose, I'll usually say, oh, are you and I, we talking about the same court? You know, which judge are you talking about? Or how many times, if we tried this 5 times, how many times would you win it? Or if I brought 10 trial attorneys in here, would they agree with you that you couldn't lose? I'll just test the hell out of them. Or if I have an attorney, and I've sometimes had this, who says to their client, you can get this amount of money. I know you can get this amount of money. I know you can get this amount of money. And I'll say, okay, will you be willing to sign a statement to your client that guarantees them they're going to get this amount of money? Well, no, I wouldn't do that. Okay, why? Why wouldn't you do that? Why wouldn't you guarantee that your client is going to get this much? What would be the reason that prevents you from doing that? Well, the reason is what? There is no such guarantee. It ain't there. And they know that. Everybody else knows it. So the sooner that's on the table, the better. So I will use that. I am confused. Help me out. I can stick that on the front of hundreds of questions. Hundreds of questions. And I'm not doing a thing but following their own logic to what? Its contradiction. To the point to where their own actions are contradicting what they're saying, and that's when I say, gee, I am confused. What do you mean? For example, in my case I did this week from the circuit court, I had the guy saying to me, I want this over, I want this over, I want this over, I'm not going to live long enough to see the end of it anyway, I don't care, I want this over, I want this over. And the next thing out of his mouth is, and I'm prepared to sue them for this, and I'm prepared to do this, and I'm prepared to do that. And I'm like, I'm sorry, but you're losing me here. Which do you want? Stay in circuit court next 3 years? Not stay in circuit court next 3 years? Which is it? Which way do you want to go here? So that every time their logic contradicts itself, I just use that to hammer them with. And I do it in a very nice way by saying, I am confused. Not you're confused, I'm confused. Help me out. So, those are very powerful. Any one on this list might or might not be appropriate for your case. I mean, that's something you got to sum up and judge up when you're looking at your case and your people and what you got in front of you. Some cases you probably could use all these and would have to get substantial movement. Some cases where some of it would be patently inappropriate. Okay. Wonder if anybody got a question or a concern? Anything else that you thought of that's not on this list of things that you can do? Because if you know a good technique, why don't you share it with us? Yes.
I guess something that I found helpful is if people have, helping people understand the basis on which they made their decision and whether that information is good and whether they need other information.
Can you give any kind of an example?
Age discrimination case where actually what it hinged on was how certain things would affect unemployment insurance benefits. Mm-hmm. And she flat out didn't know. And it was important. They did not end up settling, but they ended up with an offer, and, well, she's going to go find out what she needs to know to make a decision.
In order to structure her offer?
Right, in order to decide whether she was going to take it or not. But, just helping people understand, why they came to this conclusion. Is that a good way? Is there something else they need to know? Can they, you risk, people having, to continue things, but is there anything else you need to know? Can we find it out here? Is it important to find out here?
I think that's part and parcel of what you're doing in reality testing. How did you arrive at your decision? Was it a good one? Do you have all the information you need? Is any of your information bad? I think that's exactly what you're doing. Now notice that that's very different than some other things. It's very different than trying to change people's mind, because ultimately your goal as a reality tester is not to change your mind. It's very different than trying to steer them to a particular place that you think the case should settle for. That's very different. Or that you think it's worth. This is all about helping them identify their thought process, their decision-making process. Where do they need more information? Where might their information be a little shaky? That kind of thing. That's what it's all about. If you do this really well, and that in the context of all the other pieces of the model, the needs and interests, if you really get their needs and interests out, just flat out, and you really do this reality testing really well, that's what's going to happen. You're almost invariably, it's almost impossible not to get some movement. It's almost impossible. People are very rarely, really, when they come into a mediation where they need to be at the outset. I'm not going to say that can never happen, but it's very rare. Yes.
We talked a little bit about reality testing on the costs of the situation. Do you ever spend much time on reality testing the benefits, their perceived benefits?
No, absolutely.
I can see in some cases you wouldn't want to really disturb that or
No, I think probably the classic case of that is the landlord-tenant, where the landlord's need and interest is producing property, they want it to generate money. And their need, so called, is to get the other person out. And the benefit of that is, you know, to get another person in, a renter who's going to pay money. And one of the places that I will test that is, tell me, why, what makes you believe the next person's going to do that? How do you know that? At least you know what you got here. Yeah, this person pays you a little bit late, but they pay you, and you know that. What makes you think the next person's going to be any good? Yeah, you would definitely want to test the perceived benefit of what it is that they're trying to do. Let me see if I can think of another example where people saw something that's beneficial, and upon testing a little bit, it wasn't all that beneficial.
Well, sometimes in a case where they have this idea that, oh, I'm going to get this big judgment, or you know, there's some pot of gold there. I think there definitely would make sense to do some reality testing on how do you know that's what you're going to get.
Oh, yeah.
What makes you think that there's $100,000 you're going to get?
Oh, yeah, sure. You would always want to reality test what the range, a likely range of what winning means. Does winning mean that pot of gold, or does winning mean possibly less, maybe even a lot less? And how do you know? How do you make a good considered judgment about what your likelihood is? What do you think you can get? I mean, it really depends. Tell me.
You know, in the federal sector now, one of the things that kind of motivates a lot of people is the fact that you can do compensatory damages with EEO cases up to $300,000. And a lot of the people are active on rumor, propaganda, not real facts on how many people actually get $300,000, which is, I mean, you know, very, very low number. Any kind of money at all. But like, as far as the rumor deal go, you know, like if it's one case, I think since within the FAA anyway, I think one case actually got $300,000. But everybody has this dream of getting $300,000.
The caps.
Yeah.
Go for the caps.
Yeah, and it doesn't really cost them anything to pursue it with the federal government. So, you know, it's kind of like, why not? Now, something that's different about the way we do things in the federal government with the FAA anyway is like the mediators, they do, when they reality test, they ask about this $300,000 because it always comes up. Everybody asks for it. And they ask, well, how many people have actually gotten $300,000?
I think that's a very, very fine question.
Yeah, and you can apply it to a lot of stuff.
Sure. I ask at IDHR, one of my favorite questions over there is, do you know what the largest award by the Illinois Department of Human Rights, the commission, you know what the largest commission award was or is? And they don't, typically, but they should go ask, because it's not what they think it is. It's not large by most standards. And I think it's a good thing for them to know that. Well, what percentage of people get? First of all, you can ask what percentage of people get anything. What percentage of people get in excess of, $10,000? Those are questions for them to know. I think IDHR actually tracks those figures, and you can get them from the IDHR attorney. They would tell them. I think that's true. I don't know. Do you know?
They're careful about what they'll tell.
That could be they know and won't tell.
Yeah.
That's also a
And they don't want
possibility.
to tell too much.
But I think that's fine. I think that's something for them to consider. It's the same thing going into federal court with summary judgments. If you look at the record, the U.S. District Court in Chicago, Northern District of Illinois, should have a big old rubber stamp that says summary judgment for the respondent. And the Seventh Circuit Court of Appeals should have one that says affirm, because that's what they're doing over there day in and day out, is kicking those cases out. And people should be aware of that. They should know that's what they're up against. It's just a reality. So anything that it makes sense to test in terms of reality, I think is a very, very, all of it is good. It's all in how you set it up. It's all in how you say it. It's got to be neutral. It's got to be not intended to steer people or to change their mind, to help them think about it, and to help them add one more piece to the puzzle of how they're going to make a decision around doing what they're doing. Now, Tony, you just pointed out what I think is a really good thing for mediators to keep in mind, and a really humbling thing, which is that if it's true that a party can pursue this process and it costs them next to nothing, then what does that mean? It means why should they settle? Unless and until something substantial comes on the table, why should they settle? Now, this goes back to the idea, and I sometimes will ask my parties this. I'll say to them, how will you settle this case if you offer the other side the worst that they can do, and they offer you the worst that you can do? As long as you guys are doing that, how are we going to settle this? Because there's no incentive to settle when the person offers you the worst you can do. You might as well just roll your dice, take your chances. And in that federal sector, cost is very low. Why close it out? There's always the chance that somewhere down the road, somebody will say, let's settle this case for money. And they get something. If they don't say that, what happens? They don't lose anything. They might as well keep right on rolling. Now, what that means for you as a mediator, keep in mind, is that if a person's BATNA, remember this is all governed by what their BATNA is. If their BATNA is really good, say for an example, the federal employee who has low cost can relatively easily pursue this without a lot of problems for them. Their BATNA's good, it's strong. They don't have a whole lot of motivation to settle unless somebody's going to throw some considerable, by considerable, something for them to think about, some change on the table. Why would they? In those cases, you won't settle. You just won't. Yes.
I also wanted just to point out that for federal discrimination cases that start out at the IDHR or the EOC, if they do get to federal court and the plaintiff loses, the plaintiff has to pay the defendant's costs, which by the time it gets to trial or summary judgment are usually in the above $10,000 range. And if the defendant loses, they have to do, it's a fee shifting statute, so they have to pay the attorney's fees, which that could be $100,000.
Does that require the allegation of frivolous filing, or it's just a straight
it's in
fee
the statute.
fee shifting?
Yep.
Interesting. I did not know that.
Yep. And
I
that's
knew
really
you
good
could
reality.
you could always file a complaint based on frivolous filing.
Right, but for certain statutes in federal court, Title VII and other statutes are one of them.
Well, that's interesting. What I have sometimes done is, well, actually, I did know that too. And I believe the way it works is that it's, if you win, period, even if it's $1.
Yep, the
Right.
plaintiff's attorneys get all their fees according to the court's approval. But it's usually, by the time of trial or post-summary judgment, it's usually over $100,000 that the court will award.
There you go.
If the plaintiff gets $1, just as long as the plaintiff wins. And if the defendant wins, then the plaintiff has to pay their costs. And it's really hard to get out of it. Bankruptcy is usually
The way out.
the way out.
There you go.
What is the process? When would it get to federal court?
After the IDHR investigates, or the EOC, they give a right to sue letter, and then the plaintiff will have 90 days to file a suit in federal court. And that would start that
So
rolling.
that's after the investigation.
Right, but the investigation doesn't have to find for the plaintiff in order to get a right to sue. In
It
fact,
just
it's
has to
usually
find.
the other way around. When the investigation is at a standstill, or they don't get a chance to finish it within 300 days or whatever, or the plaintiff can request it any time, they can get a right, or even if the investigation finds against them and says there's no cause for discrimination, automatically they get a right to sue letter, and they have 90 days to take it to federal court.
In the federal sector, it can be with the EOC for a year before
Right.
they even got to consider They got so many appeals in the federal sector that by the time they ready to take the federal court, they're retiring anyway.
Well, but that's useful information.
Yeah.
Do you
How
really
long will
want
it take?
How long will it take? And do you really
Right.
want to stay in this thing for that many years? And maybe they do. It just depends. You have to look at their BATNA. Now, we've spent quite a bit of time, actually longer than I would have thought, going through all this. So we have a couple options. If folks want to stay around, I'd be happy to do a little modeling piece with Danielle as our victim. I mean, our respondent here, and we can just do CCR's standard age discrimination case, which probably most of you have either played or been a party in at some point or the other. And I could spend some time caucusing with her and doing a little bit of reality testing if you want to do that. Spend 10 or 20 minutes doing that and chatting with her. Okay. And I understand if some of you have to go, then that's okay too. You wanna do it? All I have to do is remember what this is about.
You want to hear facts?
Okay, well, Danielle, I just want to thank you for being patient and waiting and being patient with me as your mediator. I appreciate all the effort that you put into this and being as forthcoming as you've been, good information that you shared. I just want to say at this point that this part of the process is confidential, just like the rest of it. And I'm not going to share with you outside anything that you asked me not to share. Having said that, is there anything that you wanted to share that you didn't feel comfortable sharing with them?
No.
How are things going so far? How do you feel about the mediation at this point?
It's going fine.
You say it's going fine, and do you feel optimistic about it, or do you feel pessimistic?
Well, I'm not sure that he's really seeing my point of view. He's looking at things realistically.
Not realistically. You feel you have a pretty considered point of view. You thought about this carefully, and he's not looking at it the same way.
Right.
How do you feel about that piece of it? Frustrated, pissed off? What do you feel when dealing with him?
I just a little frustrated.
And let me get a piece of information clear then. I wasn't quite clear about it, of course, the mediation. How long have you worked with, or did you work with this person at RTI, or did you ever work with them?
Not directly, we're in different departments.
Now, let me make sure I'm understanding again how much it is that you originally offered, if I understood, to settle this matter. I think the total was $30,000. And the way you arrived at that was $1,500 for each year of service that he had,
Right.
and that came out to $30,000.
20 years, which equated to 20 weeks.
And you had a little louder?
Sorry.
Danielle.
Louder, sorry.
And that was that settlement figure was offered, if I'm understanding correctly, to some other